So good evening. Welcome to tonight's event, the case of Aaron Swartz, Justice in the Cyber Age. Welcome to the Center on National Security at Court of Law. I'm Karen Greenberg. I run the center. And I know many of you are new here tonight, so I want to welcome those of you who are not new and welcome our new friends as well. As you know, the center is mostly known for its work in terrorism and counterterrorism. Last year, we were given a number of special grants to develop a cybersecurity program and to look at prevalent issues in the cyber age that made sense for this kind of center that looks at national security and civil liberties. Microsoft gave us some very generous funding, and as a result, we were able to host a number of cyber events from now into whenever we decide we've solved all the problems of cyber. So my thank you to Microsoft, and we've done a number of private briefings and private events, but this is our first public cyber-related event, and so I've been thinking about it for a year and a half. This is the first time to put together a panel. And I am truly excited about our panelists tonight, all of whom know much more about this area than I do. But what's interesting is how many of the issues we're going to talk about tonight are not new. And they're not new to those of us who look at the criminal justice system and the way it identifies its battleground, its enemies, how laws need to catch up with the reality of the 21st century. I'm not going to tell you that much about Aaron Swartz. I'm going to leave that to our panelists, but I am going to say that what's interesting about this case is not just the criminal justice system and what happened. What's interesting about this case is that in the story of Aaron Swartz coalesced a number of the issues that this country is going to have to face over the next however many decades. And that is that the cyber age is one that demands a new way of thinking about the laws we have, the way we apply them, the way we understand information, the way we understand information sharing, the way we understand the global world, and how that affects not just freedom of speech, freedom of the first, and things like that, but ultimately how it affects issues of global governance. People who work in the cybersecurity field know this because they've been involved in these discussions behind the scenes for a long time. And I think that the interesting thing about this case, other than its immense tragedy, is the fact that there is so much to be learned in terms of what this nation faces in terms of defining the moral space around cyber and cyber issues. So I'm going to very quickly introduce our panelists and then let them talk in an order that I hope is the order that makes sense. I'm going to start at the end and just do this in order with Molly Land, who is an associate professor of law at New York Law School. And Molly's worked on the intersection between human rights issues in the global sphere and intellectual property and technology. Asked her here, as you will see, to give us some context in terms of what the United States is doing in this regard and what the rest of the world is doing in this regard, and how they match up, and where the civil liberties, human rights issues come into play. Scott Horton, I feel like I shouldn't have to introduce him because he's been at so many events, but he is proof of my point that the issues that we dealt with in the beginning of this new century of national security have gone from something very recognizable to Scott and myself in terms of terrorism into now this new field that involves cyber. And so much of what we're seeing, we've seen before. Some of it is completely new, and Scott will help shed some light at that on the end. He is a contributing editor to Harper's Magazine. He has a blog that you should follow called No Comment, which is, of course, a great name. He's adjunct faculty at Columbia Law School, and I could go on and on. I think he won the National Magazine Award for his work on his essay on the Guantanamo, quote-unquote, deaths, as opposed to suicide, quote-unquote, suicides that came out 2 years ago. Wesley Yang is a contributing editor at New York Magazine. He wrote a piece that brought him to our attention called The Life and Afterlife of Aaron Swartz, which sort of tried to do a lot in very little space. And he'll begin tonight in a few minutes by telling you what he learned about not just the life of Aaron Swartz, but the world in which he existed, the intellectual world in which he existed. And then our last two speakers are probably going to get very well known as being together at conferences. That's my guess. So consider this your first time, and anybody who's putting together a panel like this should have the two of you. I say that before. Ask me after, but I'm pretty sure that that'll be the case. Trevor Timm is from the Electronic Frontier Foundation, and I don't know if you know what they do, and I'm going to ask him to describe it when he starts. But for those of us who've been paying attention to these kinds of issues for anywhere the past 5 to 7 years, could have been doing it more than that, but we're not. The Electronic Frontier Foundation is where you go to see where the lines are in terms of anything from free expression to privacy to any of the other intellectual and sort of constitutional rights that surround the cyber, etc. issue. And I'll let him give a better description of it. Chris Soghoian, now this is the man whose name everybody told me I had to have. So pressure on you. Did you have a lot of time to think while everyone else is talking? So you think about it. Is a senior policy analyst in the Speech, Privacy, and Technology Project at the ACLU, which is the ACLU's way of establishing a division that will be a home for people who have legal concerns about what they can and cannot do in the cyberspace, what the laws are, what the laws need to be, what kind of challenges can be brought, what kind of new laws can be made. Maybe review, I understand, as a person who can help them think through some of these issues. And I think one of the things you need to that we all need to understand in understanding the cyber sphere is how much technologists, expertise needs to be meshed with the larger world of law and the larger world of policy. And so the ACLU has taken a step forward in trying to understand who needs to be in on that conversation. So all of this conversation will focus, I think, on the case of Aaron Swartz. So I wanted to begin with Wesley because he wrote the article which sort of takes us from the beginning to the end of this tragedy. And I thought he would just give us an overview of the case, of what it was about, and of what he learned delving into this world that really isn't his regular beat. So.
Thank you.
Yeah.
Low. So, I was interested in doing two things in my article. One of them was to look at Aaron Swartz very narrowly as a person, as a personality, as an individual. And then I also wanted to situate him in some kind of larger socio-political, philosophical context. And the way I came to, I guess we should explain the basics of the case. So Aaron Swartz was this remarkable individual who was involved in the creation of the internet, or sort of like the designing of certain parts of the internet, including RSS and the Creative Commons. When he was a teenager, he went on to be involved in the creation of website Reddit, which has become one of the largest websites in the world. When he was 19, and then he went off to have a kind of unusual career where he was always involved in a half dozen different activist projects, many of them having to do with securing, making sure things that ought to be accessible to the public, forms of information were accessible in to the public. Now, in 2011, he engaged in this game of cat and mouse. He was a fellow at Harvard, and he engaged in a game of cat and mouse with IT administrators at MIT when he engaged in a project to download a significant portion of the JSTOR library. Now, JSTOR is an organization that has taken millions of the world's academic journal articles and made them easily searchable and available to everyone that has authorized access to it, and so that means mostly people who go to elite universities. And Aaron was a person who had taken the position in 2008 that it was a great injustice for any private organization to take the labor of the intellectual work of mankind and put it behind a paywall, and to, for instance, sell a $6 article, or 6-page article for $19. He had written a manifesto in 2008 where he had said that those of us that have access to this privilege ought to be finding the articles in here that rightly belong in the public domain and releasing it to the public. Now, he was in the process of doing a batch download. By the end of it, he had taken 4.8 million articles onto a computer. The thing that he had done that probably got him into trouble with the law was that there had been several attempts over the course of a few weeks to get him off of the system, as they recognized that people coming from his IP address were engaged in this fast downloading of articles. And he broke into a wiring closet in the basement of the MIT library and directly wired himself into the system. This was directly wired himself into the system, eventually was caught. There's a sort of compromising image of him sort of going into the closet, hiding his face with a hockey mask, which some people suggested indicated that he was aware that what he was doing was wrong or not, was contrary to the law. And eventually he was sort of chased by Cambridge police and arrested. At the time, it was perceived as something troubling, but his own mentor, Lawrence Lessig, sort of acknowledged that he'd done something that was probably contrary to the law, and that he probably was going to get into trouble for. People didn't necessarily think that he was going to face prosecutors who were going to insist, as they did, that he plead guilty to a felony and that he do some time in jail. And so, over a couple of years, he engaged in an ongoing negotiation with the prosecutors that resulted eventually in no conclusion. He was about 3 months away from the start of his trial when he preempted any further legal process by hanging himself in his bedroom in Crown Heights. I became, sort of fascinated by the world of hackers that Aaron Swartz represented. And so one of the things that I want to do is read a couple of passages from a book that was very useful to me as I started to look at what motivated a person to see the question of access to academic articles as a great burning moral cause of the sort that one would risk one's safety or even life in pursuit of, because this seems very counterintuitive to those of us who have common sense notions that one pays for the things that one accesses in the culture. So there are 3 passages from a book called Hackers by Stephen Levy, which is an account of the birth of the hacker ethos at the Artificial Intelligence Lab at MIT. These passages are one of the canonical statements of the core values at the heart of hackerdom. These values were once merely the implicit rules by which a tiny subculture of brilliant, exclusively male, nonconformist, monastic devotees of the computer ensconced at MIT in the 1950s and 60s have found it useful to live by, but as computers have diffused throughout the world, they have their ethos has diffused with it. Hackers are the people who have mastered the universal machine that is able to simulate all other machines. And they are therefore a group of sorcerers of a kind, governed by their very own distinctive and very rigorous ethical code that is at once deeply in consonance with the values of a democratic society and intrinsically in tension with the way the world operates. They are in some ways some of the most powerful people in the world, though they remain very much subject to another order and another system of power that imposes a very different order onto them. And the story of Aaron Swartz is, in my view, an especially tragic instance of those two worlds of power coming into a conflict that is intrinsic to their nature. So, Levy lists these 3 values, these canonical values. And one of them is that access to computers and anything that might teach you something about the way the world works should be unlimited and total. Hackers believe that essential lessons can be learned about systems and about the world by taking things apart seeing how they work, using this knowledge to create new and even more interesting things. They resent any person, physical barrier, or law that tries to keep them from doing this. This is especially true when a hacker wants to fix something that, from his point of view, is broken or needs improvement. In a perfect hacker world, anyone pissed off enough to open up a control box near a traffic light and take it apart to make it work better should be perfectly welcome to make the attempt. Rules that prevent you from taking matters like this into your own hands are too ridiculous to even consider abiding by. Another key value is that all information should be free. If you don't have information, you don't have access to the information you need to improve things, how can you fix them? A free exchange of information, particularly when the information was in the form of a computer program, allowed for greater overall creativity. When you were working on a machine like the TX0, which came with almost no software, everyone would furiously write system process programs to make program easier, instead of everybody writing his own version of the same problem. The best version would be available to everyone, and everyone would be free to delve into the code and improve on that. So the belief that information should be free was a direct tribute to the way a computer or computer program works. What was a computer but something that benefited from a free flow of information? In the hacker viewpoint, any system could benefit from that easy flow. And three, mistrust authority and promote decentralization. The best way to promote this free exchange of information is to have an open system, something that presents no boundaries between a hacker and a piece of information or an item of equipment that he needs in his quest for knowledge, improvement, or time online. Bureaucracies, whether corporate, government, university, are flawed systems, dangerous in that they cannot accommodate the exploratory impulses of true hackers. Bureaucrats hide behind arbitrary rules, as opposed to the logical algorithms by which machines and computer programs operate. They invoke those rules to consolidate power and perceive the constructed impulses of hackers as a threat. So in my view, the preceding passages contain within them the conceptual germ for almost everything that has followed, having to do with the interaction between hackers and the law, spelling out as they do the intrinsic tension between hacker self-governance and bureaucratic control by means of the threat of physical coercion of the government. And they shed important lights on the kinds of misunderstandings that led to the prosecution of Aaron Swartz. And they suggest that these misunderstandings will almost inexorably lead to a continuous escalation and hostility between hacker underground and law enforcement, such that we're likely to see, as in previous instances of middle-class dissidents in the democratic West, a cycle in which useful idealists who are not terrorists will find themselves increasingly surveilled and imprisoned through intrusive, investigative, and prosecutorial tactics by law enforcement officers who are not fascists, resulting in the radicalization of both sides that will prod each to increasingly resemble the things they are accused of being by the other. So it seems to me that something much bigger is at stake here than the question of prosecutorial discretion or overreach or how broadly or narrowly a specific computer law is written. The question here is whether the overall social vision that is implicit in the activities, not just of Aaron Swartz and Carl Malamud, but of Julian Assange and Anonymous and Bradley Manning, the belief that the free flow of information will in itself release us from the stupidity and cruelty of the world as it is presently governed is a true one. What the activists seem to believe is that burning down institutions which they rightly associate with the Iraq War, with memos, legal memos justifying torture and assassination, with the war in Afghanistan, will only produce a better world in accordance with the general principles that were developed by a small subculture of people at MIT, but which they believe that are broadly applicable to every aspect of the way we do business with one another and then the way that we govern one another. So I think these three principles that I named provide a nearly complete description of what motivated Aaron Swartz when he broke into the wiring closet at MIT. Swartz was of the view, and he was by no means alone in the view, that locking the world's intellectual legacy behind a paywall was morally obtuse, and that he had a right to do this thing. And so he existed within a community where it was as obvious to him that he had a right to do what he did as it was obvious to the prosecutors he encountered that he had no right to do what he did and was guilty of a crime. So an interesting story that happened to me that I wasn't able to get into the article was that I crashed the Shiva after the funeral, and I met a family friend who was, he was an old family friend that had once worked at the software company that Aaron's father had once owned, and he made the point that quite a few of them. One of them was, by some accounts, the father of the computer virus. They had all known Robert Tappert Morris, who was, he's now a sort of an honored, I think, MIT professor who had at one time been the first person to be prosecuted under the CFAA for releasing a worm that took down the internet for several days. Didn't end up doing any jail time. But that he himself had sort of been investigated, had been charged, and convicted, I think, of computer hacking when he was younger. What he said was, like, we all knew what we were doing was wrong. We were just kind of kids trying to figure these things out, and the law was indulgent toward us, as there was a culture of indulgence of these kinds of activities at MIT, and there always has been. But it was a point where he said that we knew that what we were doing was wrong. And that's the difference between him and Bradley Manning, and the difference between him and Aaron Swartz. And so the thing that makes Bradley Manning and Aaron Swartz potentially more sort of admirable and sympathetic, which is that they were idealists driven by a vision that what they were doing was right and justified morally, is actually what makes them a lot more dangerous than a person who simply is driven by sort of individual greed or fealty to the Chinese, or even sort of like fealty to like a communist ideology. I mean, those people also, at one point in time, felt that they were serving the greater good of humanity by handing over secrets. What instead we have is people who have no particular sort of loyalty to, to states. They have a loyalty to a principle. And so they believe that things will be made better if they reveal things. It was done with WikiLeaks. We can see a future in which our drone designs, our nuclear weapons can appear online, driven by people who believe that the world will be better. And in some sense, you can see why that makes sense, and you can also see why this is such a huge problem for law enforcement.
Okay, well, Molly, when I'm thinking about this and having listened to Wesley, one of the things that's most apparent to me is that we're so far as a public behind in the conversation that there is no narrative to play off of. Something about this case where all of a sudden there's so many, nobody actually knows what narrative to put around it. And so you can be creative or not. What I'm wondering is, in your work, in sort of seeing cyber regulation and cyber laws evolve in other places in the world, are they more ahead of the game? Are they less ahead of the game? How is this playing out elsewhere? Where does the United States fit into this global conversation? Or it should be a global conversation.
Oh, thank you. That's exactly the question that I was hoping to address in this important discussion. I wanted to thank you and the Center for inviting me. What I wanted to do, and what Karen asked me to do, was talk a little bit about that contrast, the domestic and then also the international legal framework at issue in the case. So I'll start out with the domestic side of things. Although my expertise is more on the international side, I'm happy to talk about both. Just to give a framework for the discussion, a lot of what's been said in the media and in the exchanges has been about whether the statutes that we have that were at issue in this case were overbroad, incorrectly applied, or whether discretion was not exercised properly. And I thought it would help to start out just by talking about what those legal frameworks are, and then again bringing my international piece of it to bear, how internationally I think the law is much more robust and provides us with a framework for challenging some aspects of the statutes at issue as overbroad and disproportional. So the counts against Mr. Swartz were wire fraud and violations of the Computer Fraud and Abuse Act. So the wire frauds count dealt with the use of wire communication to engage in a scheme to gain property by fraudulent means. There has been in the discussions about the wire fraud application in the context of cybercrimes a question of whether intangible property should be considered property, whether these counts should be applied in this kind of a context. Although courts have largely found that it does apply to intangible property, including things like the theft of trade secrets. The remainder of the counts, as I mentioned, were violations of the Computer Fraud and Abuse Act, the CFAA, which broadly applies to prohibit accessing a protected computer. And a protected computer is defined very broadly as any computer used in or affecting interstate commerce. And accessing that protected computer without authorization for certain purposes or having certain results. So there were three types of counts that were at issue in the case. The first set of counts were very similar to the mail fraud, the wire fraud claims. They charged fraudulent intent, accessing a protected computer to further a fraudulent purpose. The second set of claims were charges of intentionally gaining access to a protected computer without authorization in order to get information, and specifically information valued at over $5,000. So here again, the nature of the claim was accessing a computer without authorization in order to gain information. And the final count was accessing a protected computer and then recklessly causing damage. So we're really talking about a statute that very broadly defines a set of activities involving access to a computer without authorization. Now the stakes here were very substantial. The numbers that have been discussed most prominently have been $1 million in potential fines and over 50 years in prison. Although I should note that the actual sentences that would have been imposed under the sentencing guidelines would take into account, there's a very complex structure and I'm not a criminal person, but as I understand it, it would take into account the value and would impose a structure. Estimates that I've seen, and again, subject to additional comments from the panel, would be that he potentially faced up to 7 years in prison, which certainly is less than 50, but is a very significant and substantial amount of time in jail. Now I wanted to, with that background, this is the nature of the charges that have been brought. I wanted to bring in the international side of things because what I see at issue in this case is the potential chilling effect that the possibility of criminal sanctions and very significant criminal sanctions might have on freedom of expression. And the reason I think the turn to international law here is helpful is because we wouldn't normally think of this case, I think, as implicating freedom of expression issues in the U.S. because the First Amendment has been interpreted much more narrowly and does not typically protect the right to receive information. It more typically protects expressive conduct. Under international law, though, the provision on freedom of expression and information in the International Covenant on Civil and Political Rights is very broad and protects not only the right to express oneself, but specifically the right to seek, receive, and impart information and ideas of all kinds, regardless of frontiers and through any media of one's choice. Now, this is a very under-examined provision, I think, of this human rights treaty, and one that I think could have a lot to say about these debates about our relationship with computers and platforms, internet platforms. So the right in Article 19 of the International Covenant on Civil and Political Rights, the ICCPR, in my mind, and I've argued elsewhere, that this protects a right to access information, not only to share expression, but to receive it and to seek it out. And I think this is a very robust independent value in human rights law that could be useful here. Now, this right is not unlimited, right? So we don't have an unlimited right to access any and all media of our choice, and we don't have an unlimited right to access all information. But human rights law, while it allows limits to be applied to the right to access information, says that those limits have to be very carefully circumscribed. They have to follow the principles of legality, of legitimacy, and of proportionality. So they have to be legal, they have to be authorized by law, and that law has to be transparent and accessible. They have to be legitimate, that is, they have to pursue a legitimate purpose, such as protecting the rights and reputations of others, protecting national security, public order, or public health. And then third, limits on the right to access information have to be proportional. The limit has to be necessary for achieving the purpose that the state seeks to impose, and it must be the least restrictive means of doing so. Now, again, we have similar provisions in our First Amendment doctrine, but I think international law allows these the proportionality analysis to be applied to a much wider range of situations involving access to information than simply expression. So I think the proportionality analysis is critically important in a digital age because it allows us to consider the purposes that the government is pursuing in limiting our ability to access information, the harm that is to be avoided through those limits weighed against the importance of accessing information and the role that information plays in our lives and in the fulfillment of our human rights. And I just wanted to bracket this by saying that international human rights law is not directly enforceable in U.S. courts. It's not. It doesn't give you a cause of action, and in most cases cannot be applied as a rule of decision. I think, nonetheless, that it is a useful framework for us to consider rhetorically, for organizing, for considering how things are done in other places, and for evaluating how we might think of these issues in a global framework and not just nationally. So in taking the proportionality prong of the human rights analysis, that any limits on access to information have to be proportional to the purpose to be served, I wanted to raise 4 issues that have been, a couple of which have been discussed in the press, and then also add to those issues places where there's been discussion and disagreement about the potential overbreadth and the lack of proportionality in the Computer Fraud and Abuse Act. Because I do think that we need to consider whether the Act is adequately distinguishing between cases that are truly serious and those that might not warrant the same kind of response. So one of the places where there's been critique of the Computer Fraud and Abuse Act has been in its definition of unauthorized access. That potentially exceeding unauthorized access certainly is designed to stop people from hacking or breaking into computers, but it might also include the situation where someone is accessing a computer or the information on a computer in a way that is not authorized by, for example, the terms of service that govern that platform or the corporate policies that govern your use of your computer at work. So that's one way, if indeed it applies not just to a sort of explicit circumvention of limits on access, but also of violating contractual or other policies. It's been critiqued as overbroad because it could apply to a wide swath of conduct. Now, there was a Ninth Circuit decision last year, United States versus Nozzle, that said that tried to adopt, and did in fact adopt, a much more limited vision, saying that circumventing your corporate policies, which limited what you could do with the information to which you had otherwise illegitimate access, was not a violation of the Computer Fraud and Abuse Act. The second place where people have raised concerns about the proportionality of the CFAA has been with respect to that second set of counts in the indictment, which I mentioned earlier. Specifically, the charges that he had intentionally gained access to a protected computer in order to gather information. right? So this makes a felony of gaining access to a computer that's used in interstate commerce in order to get information, which again reaches a broad swath of conduct, and several have suggested that it be limited in some way, that the trigger for making that a felony be increased. And I wanted to add two things here, and I think specifically from the international context. One way in which we could also think about potential overbreadth and lack of proportionality might be with respect to the availability of civil versus criminal penalties. We might consider being more discriminating in terms of the actions for which criminal penalties are available. So you could, for example, leave open very broad provisions that allow people to pursue civil remedies for unauthorized access to their computers, but yet limit much more stringently the kinds of cases for which we would pursue criminal sanctions, because I think criminal sanctions is a much more significant, serious, and intimidating penalty that can have much more serious chilling effects. And here, I think there's a recent case from the European Court of Human Rights that might be helpful. It deals with copyright, not necessarily access to databases, but it found that criminal convictions for copyright infringement interfere with the freedom of expression. Now, in that particular case, there was no jail time at stake, but rather a fine, very significant and hefty fines to be fair. But I found that those particular fines were within the margin of appreciation afforded to the state in determining how to impose limits for copyright infringement. But I think its recognition that it can interfere with freedom of expression is instructive. And the final thing that I'd mention is that we might also want to think about how we value damage in cases involving the CFAA. Whether that be civil penalties, how do we assess the amount of money that can be obtained in terms of damages, or how we value damage for assessing criminal sentences. We're dealing with intangible property in a digital world. And the making of a digital copy doesn't cause harm in the way that stealing a piece of tangible property might, because the cost of that copy, the marginal copy is zero. Now, it's true that limiting your ability to maintain exclusive access to intangible property can reduce incentives to create that property and or limit your ability to exploit that exclusivity as a business model, which is what the scholarly academic journals do. Now, some have argued that indeed, making available scholarly articles for free and not behind the paywall would cause some of those journals to go out of business if they can no longer charge subscriptions. But it's a different kind of harm. We may need to think about it differently than if we were talking about injury from the theft of tangible property. And I suggest this especially because when we may want to be concerned when those business models resulting in inaccessibility of cultural, scientific, and intellectual materials that are crucially necessary for the fulfillment of all of our human rights. And with that, I think.
So, I mean, one thing I think that's important to point out in thinking about reforming the law itself is that, and there are now, as one of you will talk about, or both of you will talk about, there's some movement for new legislation to sort of make different gradations in the law and the penalties and what the standards are. But you know, a number of, and one in particular legal scholar that's looked at this case, Aaron has done a number of very lengthy posts about it. And he maintained, you know, piece by piece as he goes through the indictment and he looks at the charges, he basically concludes that on all but one of the charges, Aaron Swartz would have been found guilty. And on the final charge, it was maybe iffy. And
Let's just note that this is Aaron Swartz, formerly in the Department of Justice, in the division responsible for the promulgation of these policies. Let's just not forget that point. Not a neutral party.
Not a neutral party, but as there's no one here representing the government, I thought that I would bring that up because I think it's important to understand that, so I'm taking on that role, as you asked me to. So I'm doing that, but thank you for doing that. So, what I'm really trying to understand in all of this is really less about the issue of guilt in this specific case, which, you know, there seems to be no way around the fact of prosecutorial overzealousness. But the real question is to me, how pervasive is the going after hackers? What does it look like from the point of view of if you get this kind of information, and what's really going on? What is happening in the world of law larger than Aaron Swartz?
So I'm really glad, thank you for having me here. I'm really glad that as a technologist, I think I'm the only technologist on the panel. So it's really nice that when we're talking about technology and law that we actually don't have just lawyers discussing this. I think I'm probably also the only person on the panel, although correct me if I'm wrong, who has been investigated by the FBI for computer-related activity. Although now that you're fundraising for WikiLeaks, maybe you'll be next. Trevor.
Everyone in this room should assume that they've been investigated.
Well, they actually came to my house at 2 in the morning. So
It's really investigated.
I want to talk about how the government thinks of hackers and how hackers are portrayed in popular culture and how that, I think, led to a little bit of what happened in Aaron's case in terms of the prosecution. So one of the passages that you read from Stephen Levy's book describes this group of hackers as sorcerers. And I think that's a really good term because it's really difficult for the average person to understand what a computer scientist does, and in particular, what a computer hacker does. And you see, so it turns out, I mean, I've done a lot of work researching computer security. It's really boring. You spend a lot of time staring at a screen, typing at a keyboard. There's a lot of late nights. It's not very exciting. And it turns out that doesn't make for good Hollywood movies. And so in popular culture, movies, TV shows, they have to spice it up. They have to change the act of hacking for the big screen. And you see this when you watch movies like Hackers or the latest Bond film, right? The computer geeks like dive into the screen and there's ones and zeros appearing, and it's like we have magical powers. And I think the fact that computer hackers have been portrayed this way for so long changes the way that everyone else thinks of us. We are seen to have these powers that no one else does, and that our powers cannot be contained, even if we're locked up. No, but this isn't fiction. This is how people look at us. So Aaron was prosecuted, but I think it's interesting to see what the government has done to other computer scientists and other computer hackers. Kevin Mitnick was arrested in the mid-90s when I was in high school, and there was a whole movement to free Kevin. And Kevin, in fact, wasn't even a particularly amazing computer hacker. He was a great social engineer, and he was basically a trickster. He could talk to phone company employees and use the right lingo and trick them into revealing information or connecting them to the right line. And Kevin was arrested eventually after a lengthy manhunt, and he was kept in pretrial confinement for 4.5 years, 8 months of which were in solitary confinement. This is for a non-violent computer hacker who never murdered anyone, never held up a gun to anyone's face. 8 months in solitary confinement. Now, according to Kevin, he was told that one of the reasons that he received this extremely restrictive set of pretrial constraints was that the government believed that he could launch nuclear weapons by whistling into a telephone. So this is crazy, but there's a little bit of truth there. So in the older telephone systems, you used to be able to get free calls by playing the right kind of tone into the telephone. The tone was 2600 megahertz. And you could produce this tone using a whistle that came in a box of cereal, or you could build devices that could generate these tones. In fact, Steve Jobs and Steve Wozniak, who started Apple, actually started off doing this. And there was a gentleman who could produce these tones with his mouth. He could whistle into the phone and generate free phone calls. No one has ever alleged that the nuclear weapon system is hooked up to the telephone network. Usually it's the surveillance system that's hooked up to the telephone network. But because prosecutors, I think, are legitimately fearful, and because judges are fearful and juries are fearful, we end up in a situation where society at large is scared of the potential of these hackers. Right? They don't understand what we're capable of or why we do what we do. I also want to emphasize what's been happening in the last couple of years. In January of 2012, the government raided an organization, a company called Mega Upload, which was a file hosting service. And this happened just a couple of days after the death of Soba. But in a Wall Street Journal article that came out just maybe a month or two after the raid of Mega Upload, they revealed that the government was worried that the Mega Upload seizure would piss off the internet community. And the government took steps to protect themselves. In this case, they didn't have the names of the prosecutors in the press release. I mean, normally when you have, a raid of a drug dealer, you'd have, a press conference and drugs on the table and money and guns and all that kind of stuff. And they want to take credit for this great work. In the Mega Upload case, there was no one who was shouting out, "Hey, look at me! I was the one who put these guys behind bars." And the reason is that over the last few years, we've had this movement called Anonymous, who have been a bunch of computer geeks who have used technology to lash back at the government. Now, I'm not going to say that what Anonymous did was appropriate or lawful or the right thing, but what I will say is that the actions of Anonymous and groups like them have scared the government, and amplified by the fact that computer geeks have these superpowers. I think we can better understand maybe why the government did what they did to Aaron, or why they attempted to throw the book. The other thing I want to emphasize is that we actually do live in a society where there's a lot of computer crime. And let me be clear, what Aaron did is not the kind of computer crime that I'm talking about. I'm talking about people breaking into servers and stealing millions of credit cards. I'm talking about malware being spread by criminal gangs who are using it to loot people's bank accounts. I mean, there is actual financial fraud being committed. Some of it occurring from, or being perpetrated by people not located in the United States, some of it being perpetrated by people in the United States. And it's actually tough to catch people doing that. It is tough to catch someone who takes the time to hide their tracks. And it's actually very easy to catch a computer using activist who puts a laptop in a server closet and then goes back to get it. Right?
So is your point that with Aaron, part of it was just low-hanging fruit, and they're frustrated by the inability to get real criminals doing damage, producing damage?
I think that there are so few real technology-facilitated criminals that the government can catch. Not that there are so few of them, but there are so few that they could catch. That when they do have the opportunity to get anyone on a technology-related matter, they may try and throw the book at them.
And so do you think that this was done in part as an example?
I mean, Kevin Mitnick's case, more than anything before it was, or after it even, was definitely an attempt to, I think, chill the activities of that part of the community. There are not a huge number of people who are going out crawling Pacer databases and JSTOR. So I don't think that the government needed to chill the specific activity that Aaron was engaged in. I think they were more looking to say, look, we do have the resources to go after people engaging in computer crimes. The last thing I want to emphasize, so Aaron truly was a spectacular technologist, and when you read the articles about him, and people say that he created these technologies that are powering the internet, and one of them that's mentioned is RSS. I think most people don't know what RSS is. If you've ever downloaded a podcast, you've used RSS. RSS is a way of subscribing to regular content, and so if you have if you listen to This American Life every week on your iPod, you're using the technology that Aaron created. Aaron was a spectacular technologist. What Aaron did in the JSTOR incident was not using his spectacular technology skills. Any first-year MIT student could have written. I haven't seen the script that he used to crawl JSTOR. I'd be shocked if it's more than 10 lines of code. The advanced hacker tools that he used to change his IP address or the MAC address of his laptop are built into every operating system. I mean, he had the capability to hide his trail, and he did not seek to do that. He had the ability to never get caught. He didn't do that. From the forensics report that I've seen produced by his defense counsel hired expert, he apparently didn't even try to encrypt the data on the hard drive. This is not someone who who sought to remain 100% anonymous. Aaron had the skills to hide and didn't do that. And really, in fact, all of Aaron's high-profile technology-related activism, whether it's JSTOR, whether it's the downloading of data from Pacer, none of these things actually really used his technology skills. Any technologist could have done this. But those efforts, those activities really actually utilized his guts.
So just following up on that, was there, I mean, what you didn't talk about a little bit was if he could have avoided all of this, what was his philosophical, outside of this MIT, what was his philosophical drive? Open access. Was it just a cat and mouse game, the way almost every article that takes the prosecution side describes this? I mean, what actually was going on? Two pieces of it. Sort of prankster side, cat and mouse side, and the philosophical side. I mean, a number of places in extolling him have called him a philosopher of the internet. What about that piece?
I mean, the actions that were listed in the indictment, right? The connecting to the network, changing your IP address, changing your MAC address, getting a new IP address, then putting your laptop in the closet, that isn't using the skills of the philosopher of the internet. That's the way of getting access to some content that he wanted to download. And I think it's probably best for the others on the panel to weigh into why he did what he did. But you know, the how he did it also wasn't particularly difficult. I want to emphasize that anyone can walk onto the MIT campus and connect to their Wi-Fi network. MIT probably has the most open policy of any university I've ever been to. And in fact, Harvard, although Aaron was a staffer at Harvard, Harvard doesn't have an open network. You cannot just sit down at a cafe at Harvard Law School and sign onto their internet. You know, MIT really had an open and free network. And when you set up an open and free network, part of doing that means that some people are going to show up and download movies through BitTorrent, and some people are going to do other things. You know, there's free Wi-Fi on the steps of the Supreme Court in DC, and I'm sure people have used that for illicit things. If MIT had not wanted people to use the JSTOR resource, they would have restricted it to only authenticated signed-in users. That would have been a very, very easy thing to do, but the MIT administrators, I think, wanted to have an open network and were willing to deal with the downside of that.
So Trevor, talk to us about what happens in the follow-up to this case and what's happened legislatively and where you think it's going, and give the EFF a little plug in terms of telling people what you do, because it's vast and it's important.
Sure. So I work at the Electronic Frontier Foundation. We're based in San Francisco, and for about 20 years, we've been doing all sorts of work on civil liberties on the internet, whether it's free speech, copyright, privacy, and the Computer Fraud and Abuse Act, which is what Aaron was charged under. And that's half of what I want to talk about today. And the other half is what many people think Aaron's motivation was, which is the open access movement, which Wesley referred to. So, going off of what Molly said earlier, the Computer Fraud and Abuse Act was written in the mid-'80s. And back when it was written, it was set to protect what they called protected computers, which were computers on the internet. But there were barely any computers on the internet at this time. It was government computers and computers at universities. And so, throughout the years, they started expanding the Computer Fraud and Abuse Act, but they didn't limit any of the definitions. So it turns out that everybody falls under the Computer Fraud and Abuse Act. And the worst part is, if you take the Justice Department's definition of some of these terms like, without authorization or exceeds authorized access, it turns out everybody in this room is actually a criminal, because Molly talked about the cases briefly, but there are two cases recently, U.S. v. Nozzle and U.S. v. Drew, which the government tried to essentially say, if you break the contract of the website's terms of service or an employee's computer use policy, you're actually breaking the law as well. And so, anybody who uses the internet knows that we sign up for dozens, maybe hundreds of terms of use policies. So when you sign up for Facebook, you see that huge long list of things you have to agree to, and you go all the way to the bottom. You don't read it. and you click through. And it's up to you whether you want to break this or not. A lot of people do, and they don't know it. I mean, Facebook, for example, has a policy that you have to say everything you say on Facebook is true. So if you RSVP for an event that you know you're not going to, you're breaking their terms of service, and they could potentially cut you off. And that's what they're used for. They're used to they want to be able to use them to cut anybody off from their service that they wish. And so they're written in the broadest way possible. But so what the Justice Department wants to do with this is make this breach of contract a crime. And in this case about Lori Drew, she was a mother of a teenage girl who was getting into some sort of fight with another teenage girl. She created a fake profile on MySpace that she was pretending to be a teenage boy. And she flirted with this other girl through this profile, and eventually insinuated that the world would be better off without this girl. And the girl ended up tragically committing suicide. But what she was actually doing did not reach the level of cyber stalking or harassment, so the state declined to press charges. But so instead, the Justice Department filed federal charges and said that because she used fake information and MySpace's contract says you must be truthful with everything, that she was actually breaking the law. Now, they didn't take into account the victim of this crime was also violating the terms of use because she was lying about her age, and they didn't take into account the fact that MySpace's co-founder even had been caught violating his own terms of use by lying about his age, because everybody does this. It's impossible not to with the way these contracts are written. So the one thing that we want to do, luckily in both of these cases, Nozel and Drew, the Ninth Circuit sided with the narrow interpretation, because if they were to take this interpretation, they would have to eventually strike down the statute as being so vague that it's unconstitutional. But so this is one thing that we want to change at EFF, and so we've been trying to work with a few congressional offices to craft what's known as Aaron's Law, to make sure that a situation like Aaron's doesn't happen again. And terms of use violations are where we want to start, but unfortunately that doesn't get us all the way there, because without, even if that was the law in all the US, Aaron still may have faced decades in prison. So there's two other things that we want to do. First, Chris alluded to how Aaron allegedly was downloading these articles. He was actually, he had access to the MIT network, and he had access to JSTOR. So it's not like he was breaking into something he was unauthorized to break into, but what he was doing was using technological circumvention tools like IP maskers, or changing or spoofing his MAC address, which is basically your unique computer ID. And in a lot of situations, security researchers, or even just ordinary people on the internet, use these tools all the time to protect your anonymity, or if in the case of security researchers, test their systems to make sure that intruders can't get in. And a lot of times at EFF, what we're doing is we are giving legal advice to security researchers who often do research trying to find vulnerabilities in systems, not to break into them, but to warn the public that these things are unsafe. So when they do this and release this information publicly, a lot of times companies will not take too kindly to that, even though they didn't want to fix the vulnerability when they were told in private. So our proposal goes after these technological circumvention procedures too, saying that as long as you already have access to a system, you should be able to get at this information however you want. And then finally, Molly was talking about the harsh penalty system under the CFAA. And so, we can modify the CFAA to make sure that people like Aaron, who really cause little or no economic harm, aren't facing decades in prison, and still be able to go after the real criminals who are, stealing millions of credit card numbers and really causing huge, economic damage. And by, removing a couple provisions in the CFAA that basically duplicate crimes that are already on the books, and by making things misdemeanors that are felonies, we can really protect people like Aaron from facing these harsh prison sentences, while still, making sure that people are deterred from doing both serious crimes and, if you think what Aaron did was a crime, because by having misdemeanors in the books, we sometimes forget that you can still get up to a year in jail and be fined tens of thousands of dollars. Sure.
So what Aaron is accused of doing, one of the things that happened after Aaron started downloading these articles from JSTOR was that JSTOR blocked the entire MIT campus from downloading articles for several days. And while JSTOR wasn't harmed in the process because of his crawling, and I think we could argue that the crawling really hurt the servers in a significant way, Aaron was not a student at MIT. He wasn't an MIT researcher. I mean, he was just a member of the public who wandered onto the campus.
I believe that because he was a Harvard fellow that he had access to the...
He had JSTOR access from the Harvard network. Everyone had access to JSTOR from the MIT network because MIT let anyone come to campus. I just want to push back in just a friendly way here, which is that MIT let anyone in the world access their network, and through that, the JSTOR privileges that they paid for campus-wide. But Aaron's actions caused the actual tuition-paying students of MIT and the researchers at MIT, who were supposed to be doing, in many cases, federally funded research, they couldn't access these papers. Now, I would like to live in a world where all of these papers are free, because in many cases, they've been paid for with public money. I think that professors and researchers benefit by having the papers online, blah, 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 blah. But MIT actually was harmed here, and the harm was that their students and faculty for a few days couldn't access one of the most, a very, very useful library.
Well,
I think that there is a bit of harm. And the other thing is that the CFA reforms that you've described wouldn't seem to address the situation of someone unlocking or getting into a locked server closet and plugging in a laptop. And I think we can have a reasonable discussion about whether someone should be able to clear their cookies or change their MAC address or do all these kinds of sort of technologically assisted privacy preserving techniques. But I do think that getting into a locked room and hooking a laptop up to a network and then performing actions from an access point that you wouldn't normally have access to, I do see a difference between that and legitimate research, security research, and all these other things. Do you think that's fair to say?
Well, first I said little to no harm. I didn't say there's absolutely no harm. And I mean, we're assuming that all of the allegations that the prosecution made are true here when we're talking about this. And so far we don't know if that's the case. For example, we don't even know if he was ever going to release this information. The only evidence that the prosecution had was his open access manifesto that he wrote 4 years ago, explaining that he wanted, in some way, for scientific research to be in the public domain.
But I've not seen anyone allege that the claims that JSTOR cut off MIT were... Well,
so if we're going to talk about your claim about the, going into the locked closet or whatever, if all the allegations are true, I'm not saying that everything he did should be legal. I'm saying that proportionally, that we need to make some huge fixes, because if you're protesting something, in the physical world, say you are in Fordham University and you want to, participate in a sit-in, you're getting charged with trespassing and you may face 30 days in jail. Where if it's somebody doing a protest on the internet where they want to do something similar, like a DDoS attack, they're facing decades. And so, what part of the reforms that we're expressing here aren't really just focused on Aaron. Aaron may be the catalyst, but it's important that we recognize that this is much larger than him and affects a lot more people.
But this was a network that was protected by a lock, right? There was a lock on the door, and there was a lock protecting the network. I mean,
I'm not defending everything that they say he did. That's what I'm saying.
I think I liked Aaron. I knew him, and I thought that what he was trying to do was a really important thing. But okay, anyway.
No, I mean it's a legitimate point, and that's what I'm saying. It's not, going into a locked closet is not something that we're talking about here.
One thing, just in terms of your work on Aaron's law, and then I'm going to get Scott, and then we can come back to the discussion. But one thing I want to ask is, do you think this is written in such a way that the things he's accused of, with or without the closet, let me possibly address that, would be misdemeanors?
Yeah, I mean,
As opposed to felony.
right. So, I mean, it's not saying that we necessarily are saying that everything Aaron's accused of would now be legal, but the penalties would be much more proportionate, and many of the charges, I mean, he had 13 felony counts against him, wouldn't be there.
So it does in a way go back to Molly's point about proportionality. It's like starting to see the law, yes, you can do things wrong, but the penalties for these things cannot be so egregious that would take away years of your life or whatever it's called.
If I could just add, another thing I think to remember is that there's an expressive function in the function of the law, and that we can legitimately talk about the kinds of penalties and the nature of the suit, whether it be felony or misdemeanor, civil or criminal, as a way of making distinctions between kinds of conduct that we think are more serious than others, right? So it may be that there are legitimate distinctions to be drawn rather than sort of wrapping everything up in the CFAA.
Right, and something, it's like one of those things, something you could have told us about a decade ago. It seems like we're so late to the conversation. But anyway, Scott? Scott, now I'm going to introduce you a little bit because I'm going to tell you. No, I'm going to introduce what you're going to say.
Okay.
We're going to talk about prosecutors. No, I want to say something that I want to repeat to you something Chris said. Chris said, society at large is scared of technologists, hackers, etc. Now, what's for you and me, the older people at the table, which is why we're here, to give some perspective, we've heard that before. We haven't heard it about technologists or hackers. We've heard it about society at large is scared of anybody who remotely resembles a terrorist or anybody we want to call a terrorist. And I'm sure other places of the law has heard it as well. And what I'd like you to think about is what's actually going on here. What is the larger conversation that this fascinating, interesting, troubling conversation fits into?
And I think that's right. That's a key observation. I'm not sure, by the way, that society as a whole is scared of people like Aaron Swartz. I think there are definitely a number of people in the Department of Justice who are scared. And that's a big part of the problem. But I think one thing we've seen is, in the post 9/11 period, is the honing of a lot of hyper-aggressive tools that have been justified for national security purposes, which are then applied aggressively in settings where there is no national security concern whatsoever. And I think that's one of the big questions that hangs over this case. But I'd like to pull back and look at this case, again, from a different analytical framework from some of the others we've heard before. I'd like to look at it from the perspective of democracy, our understanding of democracy, and from the perspective of citizens in a democracy. And I'm going to start with two triangles, because triangles help us simplify and conceptualize things in a way. The first triangle has three sides, of course. One is labeled secrecy, another publicity, the third privacy. That is, things that are to be kept secret, things that must be made public, and things where there is a discretionary right of privacy. And this analytical model was developed by Edward Shields at the University of Chicago back in the 1950s and 60s, when he was trying to study the expansion of notions of state secrecy and the post-atomic age, and trying to reconcile this back against the fundamental notion of publicity upon which our democracy had been created. He said that every society has a measure of these values. It arranges them and allocates a different emphasis to them. And the way a society allocates power and rights between secrecy, privacy, and publicity ultimately really tells us the values of the society. So that is to say, a democracy doesn't weigh these things equally, not at all. It places overwhelming emphasis on publicity and seeks to the full extent possible to pare back and reduce claims of secrecy. And a democracy also will respect privacy, but privacy is a right of individual citizens, not of public office holders or people who are discharging responsibilities in the name of the state. And when he put this idea forward, it was really nothing new. These are views that were put forward by the Greeks in the age of Plato and Aristotle. They would tell you that a society that places a high value on publicity, shared knowledge, is likely to be a democracy. And that there is likely to be tremendous benefit from this shared knowledge. Benefit in commerce, but also benefit in security. That the fact that you have a high level of public knowledge and an exchange and discussion of this knowledge ultimately benefits the state in keeping security. And whereas conversely, a society that puts a premium on secrecy and protects the apparatus of the state, in particular with secrecy, is likely to be a tyranny. So there is no ambiguity for these philosophers. In fact, they would say, and they did repeatedly, that leaders who stress secrecy over publicity are fools and bad rulers. In the 18th century, we saw a rekindling of this exact same idea. In fact, we might even say this was the core principle of the Enlightenment, namely that shared knowledge provides the path forward for human development. So sorcery, hacker thinking, I don't know. I'd say basic values of the Enlightenment. In fact, Denis Diderot put it this way. He said, "The attainments of science are only valuable and secure when they circulate amongst the general mass of the people, and I am impatient and adamant to take them there." And Benjamin Franklin, in his autobiography, says, well, I would like to have benefits from things I've invented. I'd love to have income from it, but it would be a mistake to hold up circulation of those rights from the broader whole of society, because the advancement of humankind depends upon that. And Immanuel Kant said the same thing. Sounds an awful lot like Aaron Swartz, actually. And American democracy was founded on these values. It was founded with the idea of protecting inventors and authors, and a recognition that there are circumstances, both commercial and security-driven, in which secrets must be maintained, but fundamentally it embraces publicity, the idea that knowledge must be shared, and that the benefits of this are incalculable to our democracy, and that to the extent this principle is undermined, we will cease to be a democracy. So, next to this triangle, I put another triangle. And on this one, we would have three sides that would be labeled science and the arts, commerce, and government. And each of these sides has different interests in the blend of secrecy, publicity, and privacy. So commerce, for instance, may be motivated principally by a concern for profit. Government may be principally motivated by a concern for security. Science and the arts should be motivated principally by a thirst for knowledge and to benefit society as a whole. And again, in a democratic society, there's no question as to which of these sets of values should be prevailing, and that is science and arts. But there is a limited right for commerce and for the government, each to pursue their own interpretations and benefits. And human history would provide very dramatic validation, I think, of these principles. The scholars of the history of science will tell you that the principle of secrecy was dominant through most of human history, certainly up to about the year 1800. And after 1800, we see the principle of publicity beginning to prevail, particularly in Western Europe and in North America. And the result is dramatic strides forward in science, industrialization, and improvements to the material conditions of humanity. So the triumph of secrecy, on the other hand, had met arbitrary government, repression, warfare, and misery. So there's rather clear balance to be drawn between these two things. So I'm painting with a broad brush, obviously, and I'm also saying the Enlightenment was right, that the kind of government that was engendered by by the Enlightenment, namely democracy, is best. And you might not agree with this, I suppose. In fact, I think there are people in the Justice Department who definitely don't agree with this. You might think that it's naive and ignores the miseries that are brought by scientific achievement, the advent of total war, for instance, or the ability of totalitarian states to use technology, which obviously they can. But still we come back to this basic principle that too much secrecy and democracy are really not compatible. And if that's a prejudice, it is the American prejudice. And in fact, I quote the words of the greatest modern scholar, American scholar of state secrecy, Daniel Patrick Moynihan, our former senator, who said, he summed it all up in just a few words, secrecy is for losers. And that's exactly right. That's the fundamental principle here. And I think that brings us to the genius of Aaron Swartz, sorcerer, hacker. I don't know. I mean, I think when I survey his activism and his engagement, it strikes me that he's someone who embraces these basic values of the Enlightenment, the critique of secrecy, and the determined advancement of the promise of publicity as a counter value. And I think he understood that there was a very fundamental relationship between publicity on one hand and democracy on the other. I think he shared, another thing, if we look at Franklin and Immanuel Kant, another writer, they note that rights of secrecy in the area of intellectual property have to be limited. They should be there for the benefit of authors or inventors. And this process is corrupted when they are captured for corporate commercial purposes. Very fundamental caveat, very true, and very much forgotten, I think, by the administrators of American justice these days. But I think that's a principle also that Aaron Swartz picked up. And I'd also just note another factor. When we go back and we look at the great lights of the Enlightenment, one thing that characterizes many of them, Voltaire, Diderot, Franklin, is a measure of impishness in the face of power, particularly when power is being wielded by dullards. Voltaire spent decades fleeing, being imprisoned. Diderot had the same problems. Franklin was also notorious in this. So this attitude of impish defiance, I think, is one that would have been respected by America's founding fathers, and indeed would have animated a good number of them. What brought Aaron into conflict with the Department of Justice? I think it's very interesting when we focus on disclosures that have come out just in the last couple of days with the publication of the FBI file. We see it goes back to initially to his efforts to break the PACER system. Now, the PACER system, as all lawyers here know, is a federally administered, computerized docket system for courts around the country in which opinions and legal filings are made accessible, and the federal government, in creating it, let's not beat around the bush, tried to turn it into a profit center, which was a defiance of the law, which says that these materials could not be copyrighted and had to be made publicly available. So we had the US government subverting the law very clearly, and we have Aaron Swartz identifying this, moving and trying to push for publication of these materials. And you know what? He was right. And when this was discovered, they launched an investigation. They tried to come up with charges against him. And spin as they could, they really couldn't come up with anything because the position the government was taking was not defensible legally. But this was a matter of immense embarrassment to the guardians of justice. And we now know that the FBI, after this incident, decided to paint a target on his back, to start going after him, to follow his movements, to look at his access and use of computer terminals. This seems to have really launched his problem. So it was on a point where he was right as a matter of philosophy and as a matter of law, they were dead wrong. He embarrassed them, and they weren't going to forget that. And I think the second incident coming up had to do with JSTOR and its disclosures. So we can debate legal issues back and forth, they're complex, but the fundamental point was his view that that the product here, these articles in JSTOR, should be available and accessible to the masses. That's this fundamental Enlightenment concept, and he was taking access to accomplish that. I think there's no question but that he broke some laws in doing that. But when we look at the attitude that prosecutors took towards him, there's no explaining what they did and against the backdrop of his conduct. I think it's clear enough to me that he had been identified as an enemy by key policymakers in the Justice Department. And why was he an enemy? Because he made them look bad. Because he was much smarter than they are, clearly the case. And because he was able to argue circles around them. He was an undesirable voice, and I think they saw this prosecution as an opportunity to silence him. And that's exactly what they did.
Anybody who might be following.
I think that's right, to create an example of him that you go this route of defying us and we will destroy you.
So I mean, the thing, you pointed out a lot of interesting things. We're going to open the floor to questions now, but the one thing I just want to point out that you said, two things you said, but I want to make sure they're heard. One is that the U.S. government, including the Justice Department, has been going in the direction of secrecy since 9/11, not before, but we'll take 9/11 at the same time that the computer and cyber conversation has been going in the opposite direction. So these were definitely going to come to a head because they were not in sync with one another. So that's the first thing. And the second thing that you said that I just want to point to is that what you're actually saying, what happens in the world of cybercrime writ large is that the attack is on capitalism. And on capitalism on the one hand, and on democracy on the one hand. And you mentioned democracy as a whole, profit, and the way these goes together. So that's something we'll have to discuss like 10 years from now.
I'd say maybe the attack was on a very warped understanding of capitalism.
Yes.
Not true, not capitalism the way it would have been understood certainly in the 18th or early 19th. And on the secrecy question, I think this is a vital point because the Department of Justice historically, we go back to the 60s and 70s, it would have been on many points a guardian of the public's right to know, a guardian of the duty of publicity. And we really see a gradual change, which I see starting in the era of Reagan, but really accelerating in the period after 9/11 to abandon the whole notion and concept of the duty of publicity and to really radically re-articulate this notion of government secrecy and claims of secrecy to make it broad and pervasive, and for the Justice Department to present itself as this guardian of secrecy.
How many events have we done on secrecy? The center, a ton.
It is.
We just keep doing it over and over. All right, so it's time for your questions. We have a few minutes, so there is a microphone somewhere. So how about this man in the middle here?
Hello. I have a question that may be for Scott Horton or Molly Land or for anyone. It seems to me, looking forward at what can be done legislatively or otherwise about this, is going to run up against culture. And there are indigenous cultures that say, okay, we'll live and let live. There's the gleaners back in the biblical times who were looked down on. And there was a farmer who argued before the Supreme Court yesterday wanting to use cast-off soybeans and plant them, even though there was a patent on their genetic code. And the Supreme Court pretty much ridiculed him, slyly comparing him to an imbecile. So it seems to me that there's this deeply ingrained cultural bias against the sort of accommodating people who are harmless that you seem to be advocating. I wonder, do you think that there's any hope in the American legislative and judicial system for making headway against that cultural bias?
Well, that's part of what I hope to inject by calling on human rights principles. I think that your triangle, the second of the two, is really instructive because what I see is an alignment between government and commerce in restricting access to information through intellectual property laws, through cybercrime laws. And I think that in order to change the debate, there does have to be a change in culture. We need to claim greater rights of access. And again, human rights law doesn't give us a legal basis, and here I am a lawyer advocating non-lawyer means, but put myself out of a job. But I think we each need, collectively need to claim rights if we believe that the borders have been pushed too far against publicity and towards secrecy.
And is there hope for getting that claim heard?
It has to be a political, it has to be a grassroots movement. I don't think it will happen in the courts. I think that the legal policies are so entrenched that the only prospects for change are really making our voices heard and saying that things need to be changed from the bottom up.
I'd say, look at Europe as a counterposed example, because, I mean, we view ourselves as the guardians of civil liberties. And in this area, when we go look at the Europeans, I mean, I've talked to prosecutors in Germany about some of these issues, and they just say their American colleagues are crazy, they're insane, and they are petrified about hackers, whereas, the attitude I hear from the German prosecutors is, well, we have to have them, we have to work with them, because these are the young kids who understand how all this stuff works, which we can't hope to do. So why are you going to antagonize all of them? I think there is an opportunity for change in this country, but it requires, motivating, I'd say, youthful activists who use the computer, who use computers aggressively, use social media and other things to speak out. And I think the case of Aaron Swartz is something that has the potential to be a change, a sea change in Washington. I'm hopeful of that, but we'll see.
So there are two things that Aaron did, two high-profile activities of activism that he did. One, Scott mentioned them both. So one was about Pacer, and one was about JSTOR. And one of those can be fixed through legislation, can only be fixed through legislation. The other can be fixed actually through the rest of us. And so the JSTOR problem is that articles that academics write are stuck behind a paywall. Usually the academics don't own copyright, because when the academics publish the article with the journal, they sign away ownership of the copyright to the journal, and then they're locked away. And in fact, there's a movement right now in the United States, and in fact around the world, called the Open Access Movement. And there are many universities that are saying that the works that they are paying their professors to publish should be available to their students and to faculty and to other professors and faculty at other universities around the world. And you have many, many universities who are now putting up repositories of academic works. In fact, Harvard, where Aaron was a fellow, was one of the first places to do that. Universities can, in many ways, solve the open access to academic works problem that Aaron was trying to address with JSTOR. The second, and actually the previous issue that Aaron was trying to address, the Pacer problem, is one that academics and universities and activists cannot really deal with ourselves. And this problem is that every single file in the Pacer system is locked behind a 10 cents per page paywall. Searches you do and the documents you download are 10 cents a page. And the issue is very complex, but basically Congress gave the courts the ability to charge a reasonable fee sufficient to pay for the maintenance of the system, and it turns out they're making a bit more money, probably like $80 million more money.
It is very clearly a profit source for the U.S. government, and suggestions otherwise are lies.
So I'm not going to defend the Department of Justice. What I will say is, from what we know, they are using it as a technology fund to pay for like flat screen monitors in the courtroom and other technology-related costs. Look, the courts have costs they're fundraising using the system. What I will say is the only way we can get those documents out of the Pacer paywall is to have Congress change the law. And I think this is something that we cannot change ourselves. There are efforts by activists. A group of people at Princeton have built a tool called Recap that lets you share court documents that you yourself have downloaded with others, and in fact that was seeded with the database that Aaron himself had accessed. But there is no way for Pacer to change without action from Congress, and I think we would, we should all have a discussion about whether it is a good thing for all of the court records to be stuck behind a 10 cents per page paywall.
And just to add on to the first half of what you said about open access, there is also a bill in Congress right now, it's just introduced about a week or two ago. It is called the Fair Access to Science and Technology Research Act, or FASTER is the acronym. And what it basically says is that any major government agency which funds research to schools around the country has to, within a year, or I'm sorry, 6 months after the research is done, post that online for everybody to see. And so, you know, it's important to realize what we're talking about here. The vast majority of the research that Aaron allegedly wanted to free was publicly funded by the taxpayers. You know, as Chris mentioned, the authors don't get a cent from JSTOR, the people who peer review it don't get a cent, and the institutes that you know, house these researchers don't get a cent either. This law would go a long way in solving that. And you know, the executive branch can actually do this themselves, at least partially. The National Institute of Health actually has a policy where they put their all of their research up after a year, and so this law would expand it to all agencies.
Who are the people in Congress that are most receptive to this?
You know, there's a few congressmen that we see on pretty much every open internet issue that really respond to these. Senator Ron Wyden is probably the most prominent example. I believe he's a co-sponsor of this bill. On the House side, Zoe Lofgren is somebody who's introduced a version of Aaron's law that's similar to what we've been proposing, though doesn't go all the way. On the Republican side, Darrell Issa, who was a big opponent of SOPA during that fight last year. Jared Polis is somebody else who's from Colorado. He's a Democrat. I think he's the only congressman to ever run his own server. He likes to brag about that. And so, you know, there is this small group of congressmen that really seem to get it, and unfortunately, it's a long haul trying to get all of the rest of them to catch up.
I'd like to get two comments from everyone who feels comfortable answering. The first one is that the government uses aiding and abetting the enemy as one of their tactics. So if Aaron Swartz would have released some scientific journal that said about particle research, genetic research, the government could have used that, well, you're aiding and abetting the enemy, because they could use that research. The second question or comment I would like to have is the Central Park jogging people who are now in court trying to fight the government for recompense. They were coerced into pleading guilty into something they didn't do. And the criminal justice system does that all the time, where they say, well, we'll give you 6 months if you plead guilty to 10 felonies. And I believe they did that with Aaron Swartz. We'll give you 6 months if you plead guilty to all these felonies. So any comments on changing the criminal justice system?
So we're going to take 3 comments and then questions, and then we'll answer them all. So Carol and Ben.
Thank you, Chris. I really appreciate having you here because you understand the terrain and where the lines rest in the terrain. Where I think often the discussion is sort of this giant mass of people who know how to code, no matter what they do or what their motives are. And I sort of like to take this to everyone in the sense that we now live in a world where those of us who still have VHSs and they're still blinking 12 are being asked to consider a way to take that which is to us not real, though anyone would, you know, like you or like Aaron would say, the internet is real, right? We see it as not, and so many of our legislators see it as ether and not substantial. And it feels like there's this need for an entire new generation of people to come into the system. That there's this almost the war against the young that I feel has happened across many, many things. We've built an incredible hammer in our Defense Department, CIA, whatever, and now it's running around looking for a nail. So I would like to ask you, in terms of the way you look at the world of technology, how would you draw a line between something that should be free in a technical sense? How can you draw a line between something that should be free and something that should not be free, so that the law can be clean and clear? Because I think this is what I hear from everybody saying is nobody knows, nobody can make a statement as to what is free.
So I think, Trevor, you were going to elaborate on this a little bit in the second half of your remarks. But I do want to question you, and maybe Scott also, about this idea that information should be free. Because it seems to me that what this debate really is not whether information should be paid for or whether it should be free, but about who should pay for it. JSTOR is one model. It's a nonprofit organization. It's funded by foundations, and it amortizes some of its costs through university subscriptions and essentially being a tax on people who would use scholarly materials. They don't only put academic articles behind paywalls, they actually fly around the world and rescue obscure journals that might not still exist in the world did they not make these digital archives. That's a valuable thing they're doing. One model of paying for it is the way JSTOR does. Another model is Google's model, which is that they go around the world and they do the same thing, but they don't charge us for it. They give it to us for free in exchange for being able to spy on us and use all of our information for their own business purposes. You know, a third model might be to spread it out among all taxpayers and say this is valuable to all of us and everyone should pitch in a certain amount. I mean, I think there are real political problems with trying to get Congress to pay for things that we think are culturally valuable, and there might even be legitimate arguments that people who are never going to use these materials maybe shouldn't pay equally for all of it, and maybe it's okay to charge people who want to look at academic articles a little bit more. I think, Trevor, you were planning to say a little bit more about the movement that Aaron came out of, which really is one side of this debate.
Right. Actually, I mean, you bring up a good point about JSTOR. I think JSTOR is kind of getting unfairly... Okay.
We're going to have one more question in the back.
Thank you. This has been a super presentation. Thank you all very much. I think it's important to emphasize that JSTOR did not initiate the prosecution against Aaron. It was MIT, an educational institution that's obviously heavily funded by the government. My question, I guess, is what has happened to the Department of Justice in our country where we have people like Aaron Swartz and Julian Assange being treated like the worst terrorists in the world? And then what do we do about it? Because it's wacky and crazy. They've gone bonkers. And what can we possibly do to correct that and say, hey, this is unreal and we need to get it corrected?
It's funny how all of these questions seem to be directed in the same way. But we're going to take them one at a time. Let's start with Trevor talking about open access, because it is something we meant to get to.
Yeah, the last questioner makes a good point that JSTOR actually asked that Aaron not be prosecuted, and the lawyers for Aaron and his parents tried to get MIT to do the same, but they refused. JSTOR is kind of the symptom of the problem, not necessarily the actual problem. They are a nonprofit. They have been opening up their all of their information to third world countries, for example, since this incident took place. But it's just basically an outdated model. I mean, before the internet, professors had, number one, no way to distribute their papers, and they had no way of finding people to peer review them. And so they sent them to these journals with the understanding that they were giving them for free, but what they were getting back was somebody to review them and then also some way to get them out to the public. Well, now we have the internet, and we don't need that system anymore. They can publish them themselves online, and as Chris was alluding to, a lot of universities are now going in that direction, and it's up to us to push them along to address what you were asking. I think if anybody's affiliated with the university, it's important to advocate for this type of release of material, whether it's advocating it to the university or advocating it to Congress to make sure that whoever's funding this stuff actually publishes it themselves within a reasonable amount of time.
Anybody want to take a stab at the war on the young? What to do about it? And does it feel that way? And do we need more younger people making our policies in Congress? Anybody want to take a stab, or just leave it as a statement?
Let me try it a little bit. This isn't about the war on the young, but this is about having more technologists assisting people in Washington, D.C. So the SOPA battle that happened in D.C. last year got a lot of press, and there are a lot of good things about what happened there, but I think one of the bad things about that led to SOPA was the fact that Congress doesn't have any computer geeks working there. They don't have, members of Congress don't have in-house technical advisors, and so when someone, when an industry went to several members and said, here's a really good bill, here are some issues that we think we should work on, these are the solutions, there was no one there who could tell them in-house they trusted this isn't a very good approach. And in fact, there used to be a nonpartisan office, a science and technology office, and unfortunately, Newt Gingrich, when he rose to power in the Republican Revolution, killed it off because it was deemed to be a waste of money. We need to have scientists and technologists advising Congress. As a technologist, I would rather that there just be more technologists in Congress. But if we're not going to have more technologists in Congress, let's at least have more technologists working for members of Congress, so that the actions of other technologists don't seem as scary. You know, it's really difficult to help people understand that from a technological perspective, writing a program that downloads 20 articles, it's the same amount of work as a program that downloads 2 million articles. It's really just how long you let it run. Right? And the script that Aaron is alleged to have written wasn't very complicated. I mean, I haven't seen it, but it probably wasn't very complicated. Aaron spent a lot of time in Washington, and he talked to a lot of people, and he tried to understand the policy process. He tried to wrap his brain around what was happening there, and injected himself into a lot of really interesting debates. And I think in many ways that was the most impactful thing that he did. I think we need to have more computer geeks in DC and in state legislatures around the country. We need to make DC an exciting place for technologists, and because you really can make an impact. I've been there for 3 years. I find it to be a lot of fun. I've been able to affect change. I know that Aaron affected change there. I saw it happen, and I've seen my friends who are also technologists who go to the Hill, who go to executive agencies, who go to independent agencies, and talk about how this stuff works. And members listen. When we tell them this is how online tracking works, this is how online advertising networks work, this is how you can stop yourself from being tracked, they always are interested to learn how this works because there's no one else telling them this stuff. And I really feel like if we want, I'm not going to comment on whether there is a war on the young or not, but if that is in fact happening, the best way to stop it from happening is to make sure there are people who can talk about what young people are doing to policymakers.
Roger that. I think we should make Washington a more fun town, and particularly for a technologist, but I think it's a really valid policy point. And something we can talk about another time. So this is the longest any event at the center has ever gone. I want to say 2 things before you leave. The first is make sure you're getting our cyber brief on Monday mornings if that's what you're interested in. You can pick up how to do that outside there. And the second is that we have a day-long event right up some of these People's Alley coming up on March 18th on 21st century warfare. The law, the enemy, and the battlefield, which will include a significant portion on cyber. So you might want to join us. So thank you for coming. Thank our panelists.
Somebody hired for it and said, hey, you're not supposed to be charging for this content. You're going to take it to court.